Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson. I'm joined here today with Maynard Nexen attorney Warren Lightfoot. Hi, Warren.
Hey, Tina. How are you?
Doing great. Introduce us to our guest today.
Yeah, absolutely. This is John Saxon, my colleague and friend. He is a leading labor and employment lawyer in this country who's practiced for 46 years. He has served as the chairman of the labor and employment section of the Alabama Bar. He is the first chairman of the federal practice section of the Birmingham Bar Association, and he is a fellow of the American College of Trial Lawyers, the most prestigious honorary for a trial lawyer in this country. John and I go way back. We've handled many cases against each other. I'm always on the defense side. He's always on the plaintiff side. Even though, John, we need to look for cases where we can work together. We have collaborated on projects together and work together. And frankly, I just respect him as preeminent in our field. I was thinking, Tina, that with the start of a new year and right here in the middle of the college football and NFL playoffs, what most employers might want to hear is a little blocking and tackling on employment issues. It's always
Sounds
good
great.
to brush up on the basics. And what type of person has the most credibility to share insight into how you treat your employees and respect their rights. I think that's an experienced plaintiff's lawyer, someone who's known for their experience, intellect, aggressiveness, and thoughtfulness. So that's why I asked John to join us.
Fantastic. Thanks for being here with us, John.
Thank you, Tina and Warren. Thanks for the nice words.
Yeah. So, John, really appreciate you joining us today and giving us some wisdom and chatting through some things. We all know that most states are employment at will states, but there are some exceptions to at will employment even in those states, of which some of our listeners may not be aware. Can you talk about some of those exceptions to at will employment?
Sure, Warren, a couple of them are obvious. If someone's a member of a union and then there's a collective bargaining agreement in place, if you've got a written contract, and some people do have, very senior executives, on-air television personalities, head football coaches at major schools, but most folks don't have a contract, and so they are at will. But there's still exceptions there. And I only practice in Alabama, so most of what I'm going to say is confined to Alabama experience. But in Alabama, we have a cause of action called permanent employment. If someone in a position to bind the company has made certain representations, promises, commitments to an employee that they relied on, particularly if they left one employer to come to them, then those are binding. And you can have a cause of action for permanent employment that is outside employment at will. You can also have a cause of action for fraud or breach of contract if certain promises were made to you and they weren't lived up to. We have in Alabama, and my understanding is some other states have similarly, commission statutes that if you work on a basis where you're paid either in whole or in part by commission in Alabama, if you make demand for commissions and 30 days go by and you haven't been paid, you've got a cause of action that not only recovers your commissions, gives you treble damages, 3 times the amount of the commissions you were owed, and your attorney's fees. And then a lot of people may think, well, we've got a valid basis for terminating this employee, and we don't have to worry about certain causes of action, but like Title VII, because we don't have 15 employees. Well, you've got common law causes of action in most states for assault, battery, invasion of privacy, false imprisonment. So there are exceptions to at-will employment, and then there are lots of ways around the numerosity requirements of the federal statutes.
Yeah, thank you, John. Those are all great points, and I would include retaliatory discharge under the Workers' Comp Act is one that we see a lot of activity in. That would be an exception as well. And then you're absolutely right on the commission statutes across many states. The one that you just mentioned in Alabama is pretty limited in its scope. It's mostly just for wholesalers. But it's still a serious statute that you don't want to run afoul of.
And John, most of our audience knows how to terminate an employee and how not to do it. And can you establish how not to do it if you want to avoid legal action?
How long do you have? I have had clients terminated who were informed of their termination by voicemail, by email, by fax. One was a drive-by letter. It was an employer that had a circular drive, where you could circle in. It was a medical facility, and you let people off and pick them up in the wheelchair when they got released. And my client was told to come by and pick up a letter. And her husband, she'd been out on leave, and her husband drove her by and she put the window down and got the letter telling her she was terminated. I have had one client who learned of his termination from the taxi driver who was there to pick him up after he turned in his company car. So folks, don't do it this way. These are the ways not to do it. And I think it is possible, except for the rarest of occasions, to terminate someone and still maintain their dignity. Obviously, if you've got an employee in a manufacturing plant, let's say, who is a physical threat to coworkers, yeah, get him out. But let me tell you how I handled it with a secretary some years ago who I terminated. It was clear within weeks of her being in my office, it wasn't going to work out. She had done litigation in state court, but as Warren would agree, I think federal court, a lot more demanding, a lot more deadlines, a lot more requirements. And so I decided to just sit her down after about a month, told her it wasn't working out, that I was not going to terminate her. I didn't want her to have a termination on her record, to go out and start looking for a job. If she needed time off to interview, fine, take time off within reason, as much as she needed. And this was kind of October-ish. I didn't want to terminate somebody with Thanksgiving and Christmas coming up. But I told her, if you're still here by Valentine's Day, you're taking too long. And so she appreciated that approach. She did not have a termination on her record, and she was gone within about a month. She found a new job. I replaced her. It was a win-win for everybody. There's certainly going to be exceptions to that, but I think you can terminate someone with dignity. And the final thing I would say is, and you may think this would not happen, but don't spread lies about the person that you have terminated. There is a church in this community that terminated its organist, and starting with the senior minister on down, the staff said, we can't talk about it because the police had to be summoned and the laptop had to be seized. Well, when you say you're seizing somebody's laptop, everybody immediately thinks of kiddie porn or something horrible. Well, the only problem is police were not summoned and there was no laptop seized. And just as the labor and employment lawyers all know each other, plumbers all know each other, organists know each other. My client heard from people around the country. What the heck went on down there? So don't spread lies about somebody that's going to destroy their reputation and give them a possible cause of action. They might not have. They may have been a valid basis for termination, but now they've got a cause of action for defamation and possibly intentional infliction of emotional distress.
Very good advice.
John, you've told me that no employer should assume its employees are ignorant of their rights in the workplace. Why do you say that?
Well, Warren, the world has changed. Right now, we are on a laptop, or I'm on a laptop by Zoom. We've all got these little devices. The internet changed everything. I think in the early days, let me talk about FMLA, either employers didn't understand it very well, or they thought their employees would not understand it very well. And in the 90s and in the early 2000s, I saw cases that were FMLA cases where lots of mistakes had been made. But I have had clients come into my office holding an inch-thick stack of FMLA regs. They can go online and find those regs and print them off. I've had clients with PACER accounts who monitor federal cases. I've had clients bring into my office Supreme Court cases that they had printed off from going online. So I would simply say, not that it makes a big difference, but don't assume that because your employees have no background in HR or business law, whatever, that they're going to be ignorant of their rights. I think a lot of them are very much up on what their legal rights are.
And John, the law in most states says that you don't have to give a reason for termination. What are your thoughts on that?
Well, I'm not going to say that you should tell somebody the reason for their termination in every case. And there are certainly instances in which an employer could get in trouble if they're not careful. But if the termination is warranted, meaning they've been written up, you followed your progressive discipline policy, they violated clearly enunciated rules, and so you've got a very solid termination, then why not just tell them the reason? I'm not going to say it's hundreds, but I've had dozens of clients tell me if they had just told me why they were terminating me after 10 years or 20 years. Warren, my record is 42 years. I had a woman in Mobile and a man in Florence, both terminated after 42 years with the company. But clients say, Mr. Saxon, if they had told me why they did this, I wouldn't be here. I wouldn't have tried to find me a lawyer. So it goes back to the terminating people with dignity. If there's no good reason not to tell them the truth, tell them the truth. And if you've got it documented, sit them down and say, look, we've got a policy that says you, whatever, can't be late so many days. You can't not show, no show, no call, those kind of things. Just sit them down and tell them. And I think it will save employers headaches. It might cut down on your work, Warren, but I think it would be good for your clients.
Yeah, John, I agree with you. Just to piggyback on what you said a little bit, I do think it's important, and I think employees deserve to hear the reason for their termination, even if it's somewhat short and sweet, right? And one thing that we always talk about when I'm counseling employers is just to be thoughtful about it and to think it through in advance, and how much might this surprise them? And never suggesting that you have to go into full detail to lay it out, to make your case. And perhaps most importantly, it's often, like 90% of the time, that's not a time for debate or discussion of, no, I disagree with that, because you're not really, you've reached the point where you've made the decision. It's really it's just doing it in a dignified way, but it gives them something, as opposed to them really just thinking the worst, assuming the worst, which is exactly what you just shared with us. So, John, sort of changing tracks a little bit, the HR world has changed a lot since you and I started practicing, including the concept of a remote workforce. We're seeing that all over now. Clients that I've had for decades, I'd say, maybe as recently as 3 years ago for some of them, allowed almost no remote work. And the one client I'm thinking of in particular now has about 50% of their employees remote. That has changed things a little bit. What are a couple of the HR problems that you've seen for employers in dealing with remote employees, and what should employers do to address those issues?
Well, one, it will take away the line I used to hear from management side employment lawyers. In an ADA case, when my client had a disability and one possible accommodation was working from home, they said, oh, no, you can't work, but that would not work. There's no way working from home would work. Well, we now know thanks to the pandemic, that under certain circumstances, working from home can work. So it may be a reasonable accommodation under the ADA. But a couple of other problems are pretty obvious. One is a security problem. In your office at Maynard Nexon in Birmingham, I assume you'll either have a big IT staff or have people who you use, vendors.
For sure.
For security reasons, but you may not have that when somebody's working in their pajamas from their makeshift office in their bedroom. So you've got a security problem that employers need to be aware of and address. Second, maybe not that big a problem, but there could be confidentiality problems. You're working from home, and there are people in and out of the house, whether it's kids and their friends or family or the cable guy. So you got to be careful about confidentiality if you're talking about privileged matters. And then third, there's a problem that there's beginning to be some case law on involving workers' comp problems. If I'm running an extension cord so that I can create my makeshift office and set up my laptop or my desktop, if I get up and trip over it, my dog is in and out, I trip over my dog or my cat, are those workers' comp injuries or not? So the area of workers' comp is one that there's been some litigation in. What I would say finally is that employers, and I think this is obvious, but let me just state it to make it clear, you've got to have a policy that addresses remote work. When can you work remotely? How often? Who qualifies? Under what circumstances? And then an employer should provide some guidance that addresses security, confidentiality, at-home injuries that might be workers' comp injuries.
And thankfully, we have time for one more question, but it is a loaded one. So get ready for this one. What general advice, let's say the top 5 things that you would tell our clients about how to effectively do their jobs to avoid adverse legal action?
Well, I could give you more than 5. We'll see what time permits. But first, I've already mentioned, but let me reiterate. Treat your employees with dignity. It's corny, but the golden rule applies. Treat them the way you would want to be treated. Do not do what one employer did with 3 very senior executives. It said, give me your keys to your company car. Here's a box to put your possessions in. One client had been there 37 years. The other 2 had been there more than 20 each. And then there's a taxi waiting outside that will take you home. That is not giving people dignity. Second, it has to do with training. And I know, and Warren, your firm is terrific about providing training for its employees, but let me just emphasize that managers and employees need to be trained on employment law, fair employment practices, and they need to be told that discrimination will have consequences. Mistreatment of employees will have consequences for them. That serves the function of prevention, and it also helps eliminate liability.
And John, let me jump in on that, the training one. It's an excellent one. You would be surprised how many sophisticated clients that we end up sort of towards the end of the road, right? The adverse decision has been made, they've been terminated, they've gone through the EOC, they've filed suit, and you get all the way to having to defend the decision. And one of the first things that a good plaintiff's lawyer like you ask is, tell me about your training and how much training you've had on it. And the answer, sometimes is just a handbook, right? And oftentimes it's really not great training, and it's just a missed opportunity for employers. Never mind, it serves them better to set out the expectations for everyone and to have that training. It's not just so you can defend yourself better in the lawsuit. It serves everyone's purposes.
Sure. The third thing I would say, and again, this may be obvious, but it is amazing how many times this happens, is please don't blindside someone. Give them warnings, give them write-ups, follow your progressive discipline policy, put them on a performance improvement plan. Don't let them have happen what happened to my 2 employees I've already mentioned who had been there with their companies 42 years, or what happened more recently with someone who was a sales executive at a large financial services company, the name of which, Warren, everybody would recognize. He goes to Orlando for the eastern half of the U.S. annual sales meeting where he gets the award as the top sales guy in the eastern half of the United States. Comes back to Birmingham the following week and they fire him. And that's not the way to do it. To this day, I'm not sure he knows why he was terminated. But that will also mean sometimes that the employer may pay dearly. Now, the fourth thing I would say is don't engage in disparate treatment. And you say, well, John, that's obvious. We all know that's illegal. You can't engage in disparate treatment. But you would be amazed at how many employers don't monitor, don't check, don't train. I took a case some years ago with 2 African-American male employees at U.S. Steel. And they were stealing time, no question. They had a swipe in card system. You swipe in the morning, you swipe out at night. If you leave for lunch, you swipe out, you swipe back in. They gave their card to a buddy who swiped them in when they came back from lunch. Except they didn't come back, they were playing. They were recorded as being there. They were stealing time. Why did I take that case? Because the white guys did that all the time, and they didn't terminate the white guys. So don't assume because you got a valid basis for adverse employment action that you should take it. You got to do your homework and make sure you're not engaging in disparate treatment. Fifth thing I would say is you got to check your files. You got to check your record. I had a client who was a very senior creative director of an advertising firm. Been there a long time, had some years on it. They terminated him. And when it came time for me to depose the guy who made the decision, I showed him the most recent performance evaluation. And he admitted, yeah, we use them all the time. Yes, they're helpful as a personnel tool. They're a snapshot in time, so forth. 3 months before he was terminated, they rated him on 21 measures. On 19 of 21, he was rated outstanding, the highest you can get. On 2 of 21, he was rated excellent, the next highest you can get. Nowhere was needs improvement, unsatisfactory, etc. And that was his most recent performance evaluation before he was terminated. So make sure you document and make sure what's documented supports your employment decision. If time permits, I can give you 1 or 2 more quick points. So the next point would be being right on the law is not enough. I had a client come to see me some years ago who was in a very competitive business. She signed a non-compete. She got a better offer from another company. She jumped to the other company, clearly in violation of her non-compete. But when I started asking questions, and there was no defense to her violating the non-compete. Come to find out that her sales manager had started hosting sales meetings at his residence in his hot tub. And this woman was fairly attractive, and he just was enjoying the view. And guess what, Warren? That lawsuit for non-compete violation went away pretty quickly. Final thing I would say is for senior managers, don't be afraid to ask the question, why does this manager want this employee gone? I could retire now if I had $1 for every time my client was gotten rid of by a manager, a supervisor who felt threatened by him or her, was afraid this person's got a lot on the ball. They're going to take my job. I better trump up some way to get rid of them. So dig into it and find out why your decision maker wants to get rid of or not promote or demote that particular employee. Folks, I hope I've said something that I got some gray hair up here. Maybe there's a little wisdom there. But Tina, Warren, thank y'all for having me. And that's all I got.
Thank you so much. That is great advice to end with. John Saxon, Warren Lightfoot, thank you both so much for your insights. And we will see you next time on Work This Way.